Testing, testing.
Hi, how are you? You okay?
We don't care about it. It's not zoning.
It's like for like.
How are you? It's been busy. It's been crazy, yeah. I'm staying as above the fray on this as I can.
Adequate notice of this meeting has been provided. Should any member of this board have reason to believe this meeting is being held in violation of that act, they shall so state at this time. Hearing none, we'll begin with the Pledge of Allegiance. And before we start, I'll ask that everybody put their phones on vibrate or turn them off. Okay, roll call. Karen?
Yes, Mr. Bezaire,
Here.
Mr. Jones,
Here.
Mr. Belasco,
Here.
Mr. Crowley, Mr. Gorgon,
Here.
Mayor Mullock,
Here.
Mrs. Reed,
Here.
Deputy Mayor Sheehan,
Here.
Mr. Lundholm,
Here.
Mr. Malloy,
Here.
Mr. Paducis.
Here.
Thank you.
Okay, we have the minutes from April 26th for approval. A motion to approve?
So moved.
Second.
I'm sorry, was that Mr. Gorgon? Thank you. We have a motion by Mr. Gorgon, seconded by Mr. Belasco. Mr. Belasco?
Yes.
Mr. Gorgon?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor Sheehan?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley? Yes. Mr. Lundholm?
Yes.
Mr. Jones?
Yes.
Mr. Bezier?
Abstain.
Thank you.
You may want to call Mr. Producers, he voted on that. I was not there.
That's okay. You can abstain. It's
did.
okay. Thank you.
Okay. All right, our first application is Thomas D. Donato, Cape May Cove LLC, 1105 Pittsburgh Avenue, 40 Harbor Cove, 1134 Lafayette Street, Block 1172, Lot 4, Block 1173, Lot 8.
Can you use the mic?
Microphone.
Can you use the mic?
Put the mic on.
Chris Balanson, I represent Tom DiDonato, who's here tonight with respect to this application for property located at 1105 Pittsburgh Avenue and pertaining to 40 Harbor Cove and 1134 Lafayette Street. Those lots are identified on your tax map as Block 1172, lots 4.01 and 4.13, and Lot 1113, Block 8, that's the Lafayette Street property. This is an application to be amend the final subdivision approval that was granted back in 2020 and request relief from a condition where the affordable units pursuant to your K-Bay's affordable housing ordinance, where they were going to be on-site, we are moving them off-site as is permitted by your ordinance. We have provided in the application package the information with respect to where they are going. They are moving to a 2-unit building on Lafayette Street, and they will not be within the subdivision. That is something that is permitted by your ordinance. There doesn't seem from your ordinance to be any ties to it, any type of justification for it. It simply is permitted, but we wanted to come before this board because this board granted that approval to get your pass on it, essentially. We have complied with the obligations under the request and provided the information that's required by your co-ordinance. Linda Glela from the Parker McKay firm, another lawyer, is here with us. Should the board have any questions with respect to her report, which has been submitted upon Craig's request? That's the application. There's no justification I'm going to offer to you other than it's something that's permitted by your ordinance. And we just are here before the board letting you know that we'd like to do it and asking for your blessing to do it.
Okay, is Mr. DiDonato going to testify?
Mr. DiDonato can testify if there are questions. I don't have any testimony for him.
Okay, all right, okay.
I mean, I can put a little testimony in the record if Mr. King thinks the record should be embellished.
Your record.
Tom, you want to be sworn, please?
Oh, you need to swear
Do
me.
you swear, do you know, Mr. Hurlis, I'm going to swear you in as well. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
That needs to be turned on.
I do.
Tom, you are the owner and the developer of the 13-lot subdivision that was approved by this board back in 2020.
Yes.
And what is that subdivision to be referred as? Do we have a name?
Cape May Cove LLC.
And Cape May Cove LLC, with their initial approval, we're going to place the 2 affordable units under Cape May's affordable housing ordinance on site. Is that right?
Correct.
You have since come under ownership of a building on Lafayette Street that is a 2-unit building that is existing. Am I right?
Yes, sir.
And your desire is to transfer the affordable units from the subdivision to the Lafayette Street building.
Yes.
And that building will be conform to whatever code requirements the ordinance provides for,
That's correct.
and is currently undergoing or finished rehabilitation for that purpose.
Yes.
Thank you, Tom. That's all.
Did you say it's being rehabilitated right now? you said?
Yes,
Okay.
yes. Where are you in terms of having it ready?
The upstairs is pretty much done. The downstairs unit, I'm waiting on some electrical equipment. That's
Some supply chain issues with building materials?
They're all over the place.
Okay.
That's all I have. Linda is here. She prepared a report. If anybody has any questions for her, she is probably smarter than I am and can answer them easier than I can.
You need to speak into the microphone if you would.
Ma'am,
Why don't you guys sit down?
Sit down.
Let the
Yeah,
truth, so help you God?
I'm an attorney.
Oh, okay, you're here to testify. Okay,
Yeah.
opinion, not fact.
I'm just testifying, well, legal, I'm going to give you some law on it. I'm an attorney with my name's Linda Galella. I'm an attorney with the Parker McKay Law Firm, and I specifically handle affordable housing. And I just wanted to point something out. I looked at the affordable housing history of Cape May City, and a couple things I wanted to point out to you that I think are very relevant. Cape May went through third round affordable housing compliance and reached a settlement agreement with Fair Share Housing Center back in 2018. And the settlement agreement that you had with Fair Share Housing Center, this development, this 13-unit development was part of the settlement agreement with Fair Share, and it was contemplated in the settlement agreement that the units could be off-site or on-site. That's specifically in the settlement agreement with Fair Share. In addition, after the settlement agreement was reached, the city adopted a housing element and fair share plan as part of your master plan, and that's what you do in the affordable housing world. You adopt that. And your housing element and fair share plan also contemplates that these units could be off-site because your ordinance does permit it. So I wanted,
You mean the 13 units in this subdivision were contemplated as into the overall number of units Cape May was obligated to provide?
that's correct. The two affordable units were contemplated, and those two affordable units could be off-site.
And the obligation was 2.6 units. Mr. DiDonato paid into the COA or fair share or affordable trust fund the city maintains to the tune of about $58,000 last year. So that obligation is satisfied.
Yes, that's correct. That was paid into your trust fund, the 0.6 share. So,
And otherwise, do you think this application as submitted then complies with Cape May's COA ordinance or plan?
it does. It complies with the settlement agreement with Fair Share Housing Center. It complies with your housing element and fair share plan. And a couple things I would also, a board has discretion regarding that. And some of the things that you look at for affordable housing, when we pick out affordable housing sites, we look at various things like, is it walkable? Is there stores nearby? Is there public transportation? Is there a supermarket? Things like that. And the site that we are looking at for the affordable units, 1134 Lafayette Street, it's very walkable. There's public transportation. So those are the types of sites we do identify for affordable housing, and I do want to point that out to you. Thank you.
Can I ask you a question? It's not a rhetorical one. It's not a rhetorical question, it's really a question. The inclusionary housing ordinance seems to contemplate that for units on-site, they would be architecturally similar. And this resolution in this instance for this site was very particular about certain commitments about the housing being not only architecturally similar, but sort of designed similarly, so that when you looked at them, you really couldn't tell them apart from the exterior. We're now kind of abandoning that and putting it somewhere else, and they will look nothing like the houses that are part of the project. Can you just speak to that, if you think that that is
Sure.
okay, and how that can be inclusionary?
Yes.
Because the word inclusionary is sort of the
Sure.
functional word in that concept.
Yeah, that's a good question. For inclusionary developments, the COA regulations provide that the affordable housing units are supposed to look like the market rate units. They're supposed to look the same, and that's part of the COA regs. But this isn't going to be really inclusionary housing because it's off-site. So the fact that the off-site units look different from the 13 units, that does not have to be the same design and the same architecture and all that. That would not apply. That only applies when you do the units on site.
And what is the theory behind that, obviously?
The theory behind that is you want the units really to look the same. You don't want the affordable units really to be singled out. You want them to blend in. You mix them up. If you have an apartment complex, you mix up the affordable units throughout the complex. You don't have them all together. And that's the COA regulations provide for that.
Tom, with your renovation of the Lafayette Street building, have you done anything to suggest that that building is being rehabilitated in any way other than a project that you would do for non-COA housing? I mean, is your plans for it the same as any plan you would do, whether it's affordable or not affordable.
You need the mic,
Decorative things
The mic.
we could do, like more, Cape May-ish around the building. The building's more like a 1952 building, but generally the whole street is kind of like that, hit and miss. But there's some, little things we could do to, kick it up, Cape May-ish.
And that's your intention to do?
Well, we can do that, yeah, yeah.
Well, I'm just, I got to put pen on paper. Are you saying that as a condition of doing this, you will agree to, I don't know, to do something with regard to these houses to, I'm trying to figure out if there was just a
Yeah,
commitment to
I
doing
have
something.
no problem. I built the building next door, which you're not aware of. I came in and initially the load of mods were going into 1138 Lafayette. The building next door, there's a 4-unit building. I was 1882 when I did that up to nice standards. The one next door, because it's not a Victorian or a Cape May or 1800-a-year building, it's a 1952 building, so that's what I'm starting with. But there's some probably things we could do, to kick it up if that's,
Would you be agreeable to doing that, to giving it
yeah,
a
I think
Victorian
anything
flair, so to
besides.
speak? Or-
I do nice things, they know I do nice things, so whatever, would work.
But otherwise, you intended to rehab that building consistent with the rest of the street?
Yeah, well, the street, other than what I did, is,
So you're saying maybe a little bit nicer, your buildings?
well, they're about equal. Some
back to
worse
Mr.
and some equal, and whatever I did is nicer.
Let's get back to Mr. King's question. Would you, for the city of Cape May, agree to add some Victorian touch or Cape May flair to that building?
I'd be happy to, yeah.
I have a question concerning the fact that the affordable housing you were going to put at Harbor, or Cape May Harbor, were supposed to be 5-bedroom houses, comparable to the other houses that are built there, 4 to 5 bedrooms. The ones on Lafayette Street are only going to be 2 bedrooms. How is that comparable to what was going to be for affordable housing to what is going to be affordable housing? Because to me, it's not like for like when you're going from 5 bedrooms to 2 bedrooms.
Well, the unit of credit is the same to Cape May City, whether you build a 1-unit or a 5-unit, you get the unit of credit. So regardless of how many bedrooms it is, under the COA regs, you will still get 2 units of credit for these 2 affordable units. So really, the city loses nothing.
Right, because back in the meeting minutes from August 25th, 2020, there was a question asked, and Deputy Mayor Hendricks asked for description side by side of the Pittsburgh Avenue Affordable Housing Unit and a market rate unit. Architect Coulter said that they were almost identical in size. Engineer Orlando agreed that the lots are exactly the same and the size of the houses are almost identical. So it's my understanding that the planning board agreed to give you this with the understanding that these affordable housings were going to be of that size. So for now, we're almost taking a loss that they're not going to be as big. They're only going to be 2 bedrooms versus the 5 bedrooms.
There's still one family, there's still one renter or one tenant.
Right, but you can't fit as many people, a larger family into it. You only have 2 bedrooms versus a 5-bedroom. You could put a family into that.
Your
I think
ordinance
one's a
is-
one-bedroom.
Oh, regular.
One of them is.
One of them is a
One was
one.
own
Oh,
one-bedroom.
regulations don't make a distinction between what you can or cannot.
Right, and I agree that, I'm not saying that there is a distinction, but it was kind of put into the planning board that it was going to be 5 bedrooms. And that's what the planning board agreed to when they agreed to the application, that the affordable housing was going to be 2 5-bedroom homes. And I just think it's more of like a bait and switch almost.
Can I ask a question? Can I ask a question of the solicitor? They're presenting the fact that there's no difference between, in the law, a 2-bedroom or a 1-bedroom or a 5-bedroom. But wouldn't like for like mean something? I mean, and that's a question, legally speaking.
Okay. I'll speak to this for a second. Can I just ask them a question first that goes to this?
Please,
And then get an answer? Okay. I want to start with the part of the prior approval that's important. I know that the minutes were read and they're marginally important, but the resolution is where the action is, so I just want to go right to that.
Which resolution are you?
The one that approved, the one that you're amending. So it's paragraph 10 of the approval that you're amending.
I trust it's accurate, I've read it.
Do my best. And it says this, and this is evidence that things are said in minutes all the time, but they don't find their way in a resolution. So when it finds its way in a resolution, I like to think I capture the important stuff. It says, Joseph Corder testified as an expert architect. He confirmed, as did the applicant's attorney and engineer, the design and architectural features of the low to moderate income housing will be nearly identical to those of the other structure, and they will be virtually indistinguishable when viewed side by side on Pittsburgh Avenue. And this is where I pour it on, because this was important to a couple of the members. The applicant understands this is an important concern of the board, and the board engineer will have opportunity to review the detailed construction plans prior to issuing any building permit in order to confirm the homes are substantially similar in design and appearance. That's pretty strong language for a resolution. So that's the condition that you're really kind of amending. Now, I'm not saying you can't, I'm just saying that that's why it's very much our focus, because it was an important discussion and element. So,
My recollection, Mr. King, of that was that the board was concerned that these houses were going to look different than everybody else's, and some stigma would attach to them as a result, being low or moderate income.
well,
That-
I'm not sure that that was the only thing on their mind. But let me just get to that, because that was the preface for what I'm going to ask you, which goes to the mayor's concern. And I don't know the answer, and I spent a little bit of time looking at it. Having off-site housing as your affordable housing is not typical. And Craig will speak to this when he goes through the history of this. In fact, the model ordinance doesn't have that in it, because inclusionary housing is inclusionary, means it's included. So it's odd to have an inclusionary ordinance, inclusionary affordable housing ordinance, that then puts things not included in the development. And the statute speaks of inclusionary housing. So it's kind of extraordinary. Now, our ordinance tries to fix that, and it says, but then you don't get the 2-unit benefit that you would otherwise get, all right? So if they could have 13 units, and they were doing this, they would only have 11 units in the development allowed. But because they're allowed 15, and they're only building 13, and that has more to do with the physical features of the property than any concession on their part, but leaving that aside, they're doing 13, and now they're staying with 13, and they're putting them off-site, okay? And I think what the board is struggling with, and I'm not making a policy decision, I'm soliciting your opinion, because you're kind of testifying sort of as an expert, but not, is one of the purposes of inclusionary housing, not just to make them architecturally look nice, but rather to include the affordable housing in amongst the regular rate housing, so that people have affordable housing in the same areas and neighborhoods as the, I'll call it regular market rate housing, I think is what you're supposed to call it, market rate housing. Because the board feels like that they approve this, I can't say what the board feels, I think some of the members feel, and I think that's what the mayor is asking, like we approve this as inclusionary to have these units in this development as 5-bedroom houses or houses of similar size. And now they're becoming like a duplex on Lafayette Street that's a 1-bedroom unit and a 2-bedroom unit. And that seems very different. Is that really inclusionary housing, inclusionary development? So if you could just speak to that, is what authority or evidence is there that you can have something that is inclusionary, supposed to be in the development, and then put something that's half or a third or a fifth of the size as the affordable housing in some other neighborhood?
You're using inclusionary as it appears in the regulations?
When you say in the regulations, I will tell you, when I look at the regulations, they only talk about inclusionary housing, and it only talks about on-site. Our ordinance seems a little different and puts in this off-site, maybe as a recognition, because in Cape May, it'll be easier to get it if it's off-site, and that's what Craig is going to talk about, and that's what I think you said, that, well, it counts towards your fair share housing anyway, so you should be happy, and that's a fair comment and position. But I think the board is also wrestling with, they thought that they were putting affordable housing in a nice big development with nice big houses for people to have affordable housing among a development, and now it's not. So can you just speak to your opinion on that? And then maybe that'll help answer the mayor's question. And also Deputy Mayor Sheehan's, because I think it's kind of the same theme. Like it felt like we approved one thing and now it's very different.
Well, I have to say, in my experience, having units off-site is not that unusual. Many towns do allow for it, Cape May being one of them. It's in your ordinance, so it's something that was contemplated.
What's another one?
Right here, Stone Harbor.
Stone, okay, Stone
They did
Harbor's
the
a
same thing,
local.
exact thing that I'm doing.
Yeah, I represent Mount Laurel Township, where this all began, and they've allowed off-site affordable housing as well.
Is it
as
like for
part
like
of the-
housing, or is it, can you have a 5-bedroom development with a 1-bedroom off-site housing? Do they really allow that?
They've allowed developers to satisfy their affordable housing obligation off-site with a different type of development, like group homes, things like that. So towns do it. When the COA regs provide, and that paragraph that you cited to in your resolution, that's pretty much from the COA regulations. The COA regulations say when you have inclusionary development and you're supposed to make it, the affordable units look like the market rate units. It's just your COA regulations say that, and your resolution contemplated that. However, when you do move the units off-site, there's no regulation that says that they have to look the same. It's only when they're on-site.
So what
you're-
standard is the board supposed to apply in order to determine if you can do this or not?
Well, it's discretionary, and I think the standard should be that you look at the site itself, this unit on Lafayette, and again, look at, is this a place that's conducive to having affordable housing? Is it walkable? Is there public transportation? Is there stores nearby? Those are the types of analysis that we do when we look at these affordable units. Is it walkable?
Well,
You know?
actually, I think the units on Pittsburgh are more walkable to a store than the house on Lafayette Street. Because the Pittsburgh Avenue is closer to Wawa, it's also. Dry dock, and the
But they're
and the
not
laundromat,
mutually
right.
exclusive, though. That's the difference. They're not mutually exclusive. We don't have to show that the units in the development aren't conducive to affordable housing. It's really the opposite, that the unit, the area where you want to put the affordable housing is conducive to it.
Right, but I would say it's not, right? The ones where it's on Pittsburgh Avenue, it's more conducive than where you're putting it on Lafayette Street. It's less, there's farther distance from the stores and public transportation, you know.
No, public transportation's closer.
Well, I don't know, there's a bus stop, isn't there, right there at the Wawa? If not, I know there's, whatever the bridge, there's one.
Bus stop?
Yeah.
If I could just ask a question, what I'm not hearing is a very, very good reason as to why you are moving the affordable housing to a different site. Why not keep it where it is? And I have a lot of opinion on affordable housing of it's always being like a can kicked down the road. No community can really come to terms with it in the nation. I was happy to see that we were doing it within your community that you're building. And I thought we would be on the forefront of it, actually. When you, let me just say in education, you have a student in your classroom who may not be doing well. The old plan was remove them and put them in a special ed and not keep them in the regular community. That was found to be not good. You keep that person in a classroom and they learn and they thrive and they become better because they're exposed to all people. I feel the same way about this affordable housing. I think it would be a very good thing in your community. And what is the exact reason you want to move it out?
I'd like to hear the applicant answer that, frankly.
Well, I don't think you can have affordable housing in an unaffordable area, and the neighbors wouldn't be too.
Well, then why did you ask for it in the first place when you had your application approved?
It didn't provide for it in the law. If it did, I would have did it then. Then they opened up the opportunity, which they should have done to begin with. It's all new to the Cape May. They never
Microphone.
did this before.
And you agreed?
They could have opened up the load of mods on-site if they knew to do that. They didn't do it. But then when they did is when I made the move. I started here
Hold on one
with
second. Before you
1138
go past that,
Lafayette.
I'm not sure that that's factually true. I thought the last time you were here was 2020, and I thought we approved that before that.
No, it's going before you, Richard. I came here with
I understand, but the question
1138
he's asking you
Lafayette
is,
to do the
on the
load of
one that you're
mods.
amending, you're amending the 2021, and at that time, off-site housing, I thought was
Yep, so
in the statute.
historically, so when he came in for preliminary approval in 2017, there was no provision in our affordable housing ordinance that permitted the off-site allowance, okay? As going through the settlement process, and I did that on behalf of the city, and I prepared your fair share housing plan, which is dated August 21, 2018. That's when that provision for the allowance of off-site affordable units was permitted. So at the time of preliminary, it was not permitted, so, and he followed through with that. What he could have done was come in in 2020 for amended preliminary and final if he wanted to do so. I think they just chose the easier path because of all the moving parts that were here to get that approved, and now he's back before you. So
Are you suggesting that request was a way to avoid an issue, or
I
like
think
a...
after, and he can explain this himself, he probably should, I'll put it on a record, but there was a lot of moving parts with this. There was, the determination whether Harbor Cove was a street, whether they could have frontage on that. There was process, and if I said anything wrong, please amend the record.
One of the complicating factors with respect to the
Can you
affordable
plug
units.
the mic?
One of the complicating factors with respect to the affordable units on site, I mean, the price of those is a percentage of market rate. And whether that works is an unknown. It may not work. I mean, for instance, there are no price comparisons at the state level, from what we understand, for even a 4-bedroom unit or a 5-bedroom unit. They're not typically considered as affordable. So we can't even get a price on those. But you have to remember, if these houses are selling for $1 million plus, it's a percentage of market rate that will drive the cost of the affordable units. And whether or not they're then affordable, is a question. Whether or not they sit is a real possibility.
Well, just to give you an idea of numbers, just building off of that.
Can you plug in the mic? I'm sorry to keep asking.
Sure. These have to be sold per a certain formula, and it's based on income, so the person will need to come in and income qualify for these units. And in this housing region where Cape May City is located is housing region number 6. And a moderate income 2-bedroom unit usually sells for about $170,000, and a 3-bedroom unit would be about $198,000 for a moderate income. So just to have some real numbers with that. The only, Mr. Hurlos, the only thing I would add to your history is when the city settled with Fair Share Housing Center, the settlement agreement expressly provided that these units could be off-site, and that was back in 2018. And then when the housing element and fair share plan was prepared later that year in 2018, it also had the same language that the units could be, which may be provided off-site at the discretion of the city in accordance with City Code 59-43 or any modifications. So it was contemplated during your settlement with Fair Share that the units could be off-site. We're not just bringing this up for the first time. It was contemplated.
Right,
You had the ordinance.
but in 2020, when you came back to the board, which was after 2018, is when that wording was put in, the resolution, saying that they were going to be similar in design and appearance.
And that wording came from the preliminary approval, because there was very little talk at final about the co-obligation. And if, I kind of wouldn't mind.
I was reading from the minutes,
I
too,
understand-
that was
I
in the
understand.
minutes.
I understand.
That didn't get into resolution, so they were talking about it.
Okay, I stand corrected.
Plus, didn't they offer, I mean, that's the way they presented it in 2020, as I recall. It's a shame, there's only 4 people on this board as board members that were here in 2020, plus Craig and Reg. So 5 board members were not here for that presentation. But the way it was presented and the way I recall it was showing the layout with the 2 affordable housing. That was part of what was presented.
Well, I can tell you that I believe this gentleman started in like 2010.
It was 10 years,
Well,
it was a 10-year
somewhere in
process.
there. I mean, there was one neighbor who was extremely, an attorney, who just basically pretty much held things up. And it went through probably 3 or 4 different gyrations of subdivision. There was going to be a road down the middle at one time. Mike, you remember those? It was extremely, it's one of the longest applications, it's the longest application I think I've ever seen. And it was mainly because there was opposition from some of the neighbors, in particular one. And the very first application that came in was to have housing, affordable housing on Lafayette Street. It was a different building, but that was the very first application was heard. And that didn't fly. Then he came in and did another one where he was putting a street down the middle. That didn't work out. I mean, there was so many different changes to this, and eventually I think that one neighbor sold. So the opposition, and I think.
But Bill, if I could comment on that, the history of this project, clearly a big, long one. There's no question about it. But this discussion starts in 2019, when these folks asked for and received the permission to build these buildings with the understanding that 2 of them were going to be affordable housing units. And now they're asking to be absolved from that requirement, and I haven't heard a reason why yet.
We're not asking to be absolved. We're asking to move the obligation to the
Well,
location.
you can tell me how many angels dance on the head of a pin, but I'm telling you that these 2 buildings are not value for value.
Not comparable is what you're saying. I
Yeah.
understand that. I don't disagree with you about that.
Mr. Bailey, I
Yeah.
had an opportunity to look at the Stone Harbor ordinance. And what that says, in paragraph 5 of it, it says that the residents of the affordable units have the same full and equal access to all the amenities, common areas, and recreation areas, kind of saying that they get to be part of the community. But then it says, affordable units shall be required to be on-site unless FSHC provides written consent for off-site. So it doesn't even sound like the town reserved the right to make it off-site. They have to go to the, Greg, Fair Share.
Fair Share Housing Center.
But your settlement agreement with Fair Share Housing Center specifically says that, that's a different town. Your agreement with Fair Share said it could be off-site.
I agree it could be off-site. I'm just wondering, what are they asking FSHC? Like, what are they reviewing it for? So you have to ask them permission. What are they doing with it? Are they getting it and saying, well, you can have it off-site automatically because you asked for it? Or are they applying some standard that says, wait a minute, you're putting them outside of where all the other amenities are, the rest of the neighborhood? What does FSHC
Fair
do
Share,
with that when
yeah,
you get
fair.
it?
It's in their regs. It's discretionary. And that's the standard.
I think it's pretty clear that we allow for off-site housing, so we allow for it. But what's not clear to me as a voting member is this like for like. Because I think the idea in the like for like, the way I hear it, is some kind of comparable value. We're talking about 10 bedrooms plus the 0.6, call that maybe 13 bedrooms, down to 3. So that's what I'm struggling with in trying to see. Off-site housing, frankly, I think could be interesting. Perhaps you'd have more housing for more affordable housing instead of multi-million-dollar properties. And I think if you're in Cape May, you're in a good place no matter where you're at. So personally, I'd rather see more, and if that was a possibility, but I'm not seeing that in this application.
Mr. Mayor, Madam Deputy Mayor, board members, what we'll do is, rather than have you vote on this application this evening, let us withdraw it, and we'll come back to you with more information. Because clearly, we need to look at, like Rich says, what standard of the state may be. But rather than discuss this all night and hold people up, let us withdraw this application and come back before you and present you with more information that we think may be helpful to our position, of course, and more informational to you guys.
I can just speak for myself. I personally would appreciate that. I'm asking these questions not to give them a hard time, because I truly don't know the answers, and I want to be able to advise you guys on what standard we apply. Like, we have a statute, we do a balancing C2 or a C1, like, what is the standard of review? And discretion, I get, but discretion has boundaries. Now, we heard helpful testimony about, busing or, access to things, but I saw this, and I just read the Stone Harbor.
Right. They did a similar thing to what I'm doing. They put a 4-unit building, and they're rehabbing it.
Okay, well, maybe that's something we can develop
And
and
that's
come back,
what,
but
yeah, we're very
what I'm
similar.
saying is,
But to answer Zach's question, we could do another unit. I mentioned the Lou. I have space to do a 3rd unit there. I'd be willing to do that if that's
Those are the
what
kind of
you're
things,
looking
Tom,
for.
those are the kind of things we're going to come back with and present that.
I'm just letting them know that there's some other options.
One thing I want to look at too is the 4 and 5 bedroom units and how they get priced and whether or not that's something that the state ever contemplated.
yeah, I think the board just needs a little bit more help on a guidance.
Sure.
Exercising their discretion. They may exercise it one way or the other. I don't know that it's clear. I don't know there's enough data in the record.
And so
to
the,
do that
so the
fair.
board understands, the reason I withdraw the application is because once you guys vote on it and you vote no, then we're precluded from coming back. So I want to have the opportunity to come back and give you the information that you're asking for.
That's up to the chairman. He'll deal with that.
I have one other question. The houses you built already in that development, because you promised the 2 affordable houses, were you granted any special leeway with setbacks or expanding the house on the property, or was everything meeting to code, regardless of whether you were doing the affordable housing?
Ed, you
That
can
was,
tell.
that was about a 5-year process.
About the density, because
No.
just in my reading, I have the impression that certain density requirements there was relief on density because of the affordable housing.
So did you take advantage of that with these buildings?
I would tell you no, because 15 units are permitted, 15 lots were permitted, and Tom did 13.
I'll explain that for you. I can't-
Okay.
And there was a relaxation of the bulk standards, the setbacks, and things like that. Under your ordinance, that's allowed, and that was done in the court, kind of handled that. The court imposed those.
But isn't Maryland,
Let Rich explain that to the.
all right.
I'm sorry. Okay, this is terrifically complicated, so I'm going to try to give you the abbreviated version, because it took like an appeal and a judge's decision and everything. Okay, so you do get a density benefit by doing inclusionary fair share housing,
It's automatic.
okay? I don't know what did I say.
20%.
Okay, so you do get it, all right? Now, it was unclear what that really means in terms of lot sizes. So we went up to Judge Mendez, and he gave us guidance. And you take the size of the property, you divide it by the number of units, and then that becomes your minimum lot size. That was his ruling. So what they did was they came in with a plan that had every lot meeting the lot size, which was 6,667 square feet, so something like that, okay? So they complied with Judge Mendez's order, and it was a by right plan. Now, on the
This is in my report, by the way, on page 5.
According to the calculations, okay, based on the size of the property and the inclusionary housing 40% benefit they get, they could have 15 units, right? They proposed 13, not 15. Okay, but remember that number 15, right? Now, the reason why they proposed 13 units wasn't so much them being generous as it was that the lot, there were wetlands on it and stuff. So really 13 was the most they could really fit mathematically on the lot. But nevertheless, the statutory language, ordinance language, gave them 15 units. They only proposed 13, okay? Now, you get that when you do it on-site, with the house, the fair share on-site. When you move that off-site, whatever the number of benefit was that you got, which in this case is 2, all right, you lose that benefit. So they would have to go from 15 to 13. But they only proposed 13. So that's why they're not losing any lots by doing this, because they were already 2 lower than they could be. So they stay at 13. That's a quirk. Whether that makes perfect sense or not, I'm not sure, but that is what the ordinance says. So they're within the ordinance. So now we're moving them off-site. That's permitted. All right, hold on, let me finish. I'm going to give the whole thing at once. That's permitted, and it's encouraged. because the state has approved that and worked with Craig saying off-site is a good thing, right? Because you just want to get fair share housing. What everyone is struggling with now is, it was proposed, and it was a condition of the prior approval, that they would be similar to the big houses that were going in the development. Now they're putting them off-site, and they're going to be smaller, all right? Different. very
And
different.
fewer.
And different, they're just different, but they still count as a unit of fair share housing. Now, what we don't know completely, and what they're gonna go back, if you let them, if the chairman decides to do it, is to come back with a clear understanding of why that's okay. Now, you may conclude it's not okay, and that's gonna be your discretion, you're gonna do that. But right now, it's such a, it's a quirky area of the law, it's not common, that I think maybe you need to hear more about why they're doing it, what Lafayette's really going to look like, because now we have some vague promises about making it Cape May-like, I don't know what that means. And maybe they're going to come back with showing you what it's really going to look like.
Do I understand you that because they're moving it off-site and all that with the courts and 13 lots, they cannot build on those 2 lots where the affordable housing were going to be?
No, they can absolutely do it.
They're gonna build.
Because they're going to have 13 lots. They're going to have 13 lots, 13 houses.
Okay.
At market.
Now, are they going to, when they move if they move it over to Lafayette, would they be granted relaxed variances over there because of them moving it there?
Well, that wasn't, I will tell you, I didn't study that very hard, but there is some talk about relaxation. I don't know if that applies to where it goes. I think it said something about that, but I don't think they're requesting
It's an
that.
existing building.
It's an existing
We're not
building, not
asking-
expanding it, so.
Existing
Oh, I don't know, he was mentioning putting on another unit, that's why I was,
It's part of the structure that's there, but I can convert another one-bedroom. So instead of 2, there'd be 3.
Can I have a technical question to Craig on that issue? What does R2 require in terms of a dwelling or a density?
It's a duplex, too.
Tom, he's asking, Greg.
So R2 is single-family dwellings.
Only.
Only.
How can you put, how can you?
But,
It's there.
no.
I know, the
But
other-
affordable housing units are permitted in
Yeah.
accordance with the code. So if they're affordable, they're permitted.
They're-
By right use.
Right, so you can have apartments in that by right
Yeah.
use, that was the
Correct.
2019, okay.
So
Except for the
they have to
three.
be, affordable units, all of them.
Under that scenario of making it 3 units,
Yes.
now it would need variances because you're taking it, making it more non-conforming.
No,
No?
because they're affordable units. You're allowed to have multiple units.
even though they're not be
Yeah.
lot size?
So
We'll
you,
take a look at that, but this is the first time I've heard 3 units
Yeah.
proposed to us, so,
just because it would be a change in the
Yeah.
property.
right.
Well, we'll see, we'll deal with that when it comes.
Right.
I just have one last question. If the affordable housing was on that site, they have a homeowners association with that?
You have association, Tom?
Just for the drainage system.
For whatever the shared infrastructure is, there's an association, yes.
Well, why I was asking is, I understand that the houses that are facing Harbor Cove would be having a boat slip, access to the tennis courts and everything else. I didn't know if that included the whole development or just those couple houses on the cove.
Tom, can you answer that?
Just the code.
Okay, so one of the low-income housing would be on the cove. So that means they would have access to the tennis courts and things like that.
And there's a question whether or not they'd be obligated to pay those fees as well, which we have to look
All
at.
right.
Okay, but I guess my question too is with the homeowners, is it one person cutting the lawn or is it individuals? Individuals, okay.
Property maintenance is everybody's obligation.
And usually with those homeowners associations, the
You have to speak up.
the low and moderate income units are not granted any kind of preferential discounts. So the low and moderate income households have to pay the full HOA fees.
And the 3 or 4 lots on Harbor Lane somehow are being tied into that harbor project. And there's a steep annual contribution that has to be paid into that association. It's over $10,000 a year. So that's not an affordable house.
That's a concern.
That is a concern.
Wow.
But that's not for us to decide.
No, it
Give you more
isn't, nope.
information about that.
So how about somebody make a motion that we continue this until, and just.
No, they said they were going to withdraw it.
Pardon me?
They're going to withdraw it.
Withdrawal's the wrong
Okay,
word.
so, okay.
Adjourn it. Carry,
Thank you,
carry it. I
thank you,
apologize.
thank you.
You're absolutely right.
Okay.
Can I just make one recommendation? Okay, so in reviewing this, and Mrs. Gael, is that, I spell your name?
Galella, right.
Galella? What she indicated is true. It's at your discretion. It's specifically, and as part of the settlement agreement, that's Appendix 1 of the Housing Element and Fair Share Plan, it specifically says, the city recently approved as part of the ordinances adopted in response to Cape May's previous substantive certification, a 14-unit development including 2 on-site affordable units, in parentheses, which may be provided off-site at the discretion of the city in accordance with City Code 59-43 and/or any modifications to such code that may be applicable to this development, and a payment in lieu of construction for the fractional remaining requirement at Block 1172, Lot 1. That is specifically part of the settlement agreement for this specific property. So it's at your discretion. As part of this like-for-like discussion that we've had, I've read the ordinance numerous times trying to find any direction. I'm an engineer and a planner, so I like to have, like, okay, what am I looking at? How should I be, evaluating this? The ordinance is absent any evaluation for like. So hopefully you can come back and bring us some information as to what's appropriate like for like. That being said, the number of units as part of our affordable plan doesn't contemplate bedrooms. You'll get the unit credit. So what she indicated was correct. So, and if we can bring a third unit in, that may even be better. So just something to bear out. But so hopefully you can bring this information back to the board.
That's actually a good point, that if there is a third unit, you'll actually be ahead of the game when it comes to crediting, because it's the unit of credit that you get. It doesn't matter how many bedrooms it is, so.
There's still some serious like-for-like issues that the board has.
Yeah,
Yeah.
especially when you're.
Big time.
Yeah, I mean, because you can put a family in a 5-bedroom, you can't put a family in a 1-bedroom. And that seems to be some of the issues with low-income affordable housing.
I appreciate you trying to go back and amend this.
Oh, you want to make
okay.
that motion?
I'll make a motion, we accept the client, the
Can I make a
applicant's.
comment? There's no motion, you're withdrawing it, right?
No, he's not.
Carry it.
A motion to carry, yeah.
To adjourn.
I would like to make a comment before you take a move on this, and that's this, that I haven't heard enough of the impact on the city's fair share plan, which is expiring when?
July 1st of 2025.
2025 is the next round comes.
Okay, so I would like to know a lot more about whether or not this proposal, I'm pretty sure I know why it's good for the builder. I want to know why it's good for the city. And I haven't heard enough to justify any kind of support for this sort of thing, unless I can see the city at least coming out even.
It's my opinion you're going to come out even if you get 2 units. Now, that being said, that is not what you're tasked with. You're changing a condition
Yes.
at your discretion.
Yes.
So that whether we get the 2 units or not is not really weighing on my mind, and probably is not weighing on your mind. I think I'm getting the impression that the like-for-like issue is leading the charge here.
And in addition to that, the way it was presented the last time they came here, they presented it, this is what the development is going to be, and we're putting 2 affordable unit houses there, and that's what we heard.
Right.
And that's what we approved. And
I'd like to hear a lot
I'm
more.
not disputing at all what you said.
Yeah, I'm talking-
And like from light, I wouldn't want
Yeah.
to see a house like that built at that Lafayette location, let's say. or
Well, there's a technical
like that.
aspect of
That's
this, of
something-
whether we're complying with our affordable housing settlement.
Right.
one
And I
thing.
think we are, if we get 2 units, whether they're on-site or off-site.
Right.
And it doesn't matter how many bedrooms.
But my thing is what
But-
was presented the
That-
last
and
time,
that's-
and
So-
the way everyone voted at that time based on what was presented.
Right, so that's the condition, and that's the discretion that you guys are going to exercise.
And my recollection is, at final, and I may be wrong, is that me or one of us said that we may come back with an application to move these off-site, but for purposes of now, they are on-site, and you heard the testimony. That's something I'm going to look at in the transcript as well, just to make
There
sure.
was a time when you guys applied with it off-site.
I know.
There was. There was. This is a long history. I'm just, the chairman has asked me about the public, because I can see there's people popping up and down, but, I'm sorry?
No, you're answering that question.
Oh, okay. I told the chairman that, you know, it's okay, he wants to hear from the public, and that's fine, and we will let the public talk, but I'm begging the public, for the purpose of helping them formulate what to come back with, maybe it's helpful to hear your comments, but we're not voting. So if you have a 1-hour presentation plan for this, please just save it for when it matters most. So with that, you know, prayer for relief, I think the chairman's ready to open it to the public.
Yes, sir.
Just to be clear, if it gets approved off-site, do they get 2 more building lots? Okay.
Well, they get,
Where the affordable houses are gonna be, there's gonna be regular houses.
That's going to be.
No, but they get 2 houses.
So they're gonna
can
add 2
sell at
more.
market price.
No, the subdivision's gonna be the same.
Oh, okay, okay.
Right
So it's
now,
11
on
and,
subdivision, there's 13 lots. Right now, 2 of them are affordable housing.
Got it.
If you put it off-site, there's gonna be 13 lots. All 13 of them are gonna be market rate housing.
Unrestricted market rate houses.
so does that affect the amount of affordable housing they need to provide? Because there's going to be more of it,
Oh,
more market
right,
price
yeah.
housing.
What's that?
right.
Does that affect the amount of
No, it's
affordable
based-
housing they have to provide because there's more market price housing now?
It's based on the number of
There's
lots.
13 instead of 11.
It's done by the number of lots. Remember the explanation he gave about the 40% and the size of the lot, and it came out to 15, but they're only putting 13? So 15 is the magic number. 15 is the number that they're allowed with the density benefit that they get.
On this particular subdivision, that's true, but the overall calculation as to how many units we owe comes down to the number of market units that are created. So whether 2 out of all the market units that are created in the city of Cape May makes a big difference or not, but in that little calculation, there could
Craig
be.
can speak to that. I don't know what went in when they did your calculations, if it was 15 or 15.
With respect to the public, I mean, I don't think it's fair to the applicant that they get 2 bites at the apple. We could comment be reserved for,
But if you're going to come back with something and hope it to be approved, wouldn't you want to hear what the public has to say, so maybe you can incorporate their concerns in your presentation?
I certainly would,
Let's
Up to you,
have a little
Mr. Chair.
latitude here, let them speak, and we'll,
They're exercised. But if you could just try to limit it to things that are helpful, that would be helpful. Right?
Bill Sigger, Vermont Avenue.
I have to,
Swear in.
tell me your name again?
William Sigger,
How you spell last name?
S-S-E-E-G-E-R,
And your address?
1361B Vermont Avenue, Cape May.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Okay. Received the certified letter. I live within 200 feet of the property. I remember this project. Well, of course, it's across the street from me. And when it went through the process for the approval, and quite frankly, the give and take and negotiation for this property to get to the point to where it is. When I say to the point of where it is, I mean including those 2 affordable housing units. I'm not sure, but I think the city's affordable housing code, or at least somewhere the wishes were to give as many people as possible without penalizing builders, a chance for as many people to have a piece of the American dream, all right? To own your own home, not to rent a home on Lafayette Street, but to own a home. Now, as a result of the give and take of this negotiation way back when, how many lots can be there, on all the details that went into that, which included different factors on how driveways would be constructed, and I believe these 2 units were to share at one time the same driveway, which would come on Pittsburgh Avenue. Could be wrong on that. But that's just to give you an illustration of a lot of things that were discussed. Okay? So now, a few years later, after real estate pricing skyrockets, they come back with another idea. This idea purely is for financial. It's not for the benefit of getting people who don't have cars to live closer to the city where the Acme is or anything like that. If I can build a couple more $1 million homes than a couple of $300,000 or $400,000 homes, why shouldn't I give that a try? When before, they were trading off anything they could to get the initial approval for this project, which they got. Now they're reneging and changing the rules in which that, or at least the agreement, which was originally discussed. So I'm asking, as a resident close to the property, is that you decline this request, because the original was negotiated in length, fully by this board with the builder. It's gone on long enough, and there really isn't much more that needs to be agreed to or should have to be agreed to by this board. And I would request that you take it as it was originally approved without any modifications and just go ahead and vote on it tonight. Thank you.
He's taller than I am. Patricia Gray Hendricks, 106 Trenton Avenue, Cape May.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you
I
God?
do. While I acknowledge and I understand that Mr. DiDonato's initial application to develop a 15-lot residential subdivision in Cape May dated back to October 2012, my direct involvement with this application began September 12, 2017. At the time, I served as Cape May Planning Board Class C member from 2017 to 2020. We've heard tonight this is a complex, difficult matter for this board, given the time span, the lengthy meetings, the intricate plans that have been presented, and the burden of the new members on this board. I won't bore you with the rest of what I had to say with regards to bit by bit, comment by comment. I think the Deputy Mayor Sheehan pointed some out. The solicitor did go ahead with talking about some of the conditions. But at the same time, tonight, the board has before them an application requesting that they take out their file of the previous site plan approval, turn it upside down, and allow the applicant to start with a clean slate in regard to the affordable housing on-site units that were part of that August 25th, 2020 Cape May Planning Board meeting. Given that I am no longer a Cape May Planning Board member, as full disclosure, I hold a New Jersey broker's license as a real estate professional. And I think that with disclosure, I think it's important that it should be noted, and that you haven't heard it tonight, that the applicant purchased 1136 Lafayette back in 2014 with plans to provide off-site affordable plans for his initial site subdivision plan. As the subdivision lingered, as Chairman Bezier indicated the length of all of this and the litigation involved, the property was sold, 4 condo units, beginning in 2017, and it is now known as 1138 Lafayette Street. The proposed 1134 Lafayette Street property went under contract as a duplex back in September of 2017 and closed in December of 2017. The proposed 1134 Lafayette Street off-site affordable housing is indeed and has been the applicant's backup should this planning board vote to grant the applicant approval tonight. Additionally, it is critical that this board understands that the designated affordable unit, Block 1152, Lot 4.01, according to the Cape May tax records, may have been already sold December 23rd, 2021. And the Harbor Cove lot, which is active on the MLS today, the 4.05 designated affordable unit, is also on the market for well over $2 million. And we heard about an HOA, and in the MLS, it details the fact that the homes located on Harbor Cove are subject to Cape May Harbor and Yacht Club HOA fees of $1,890 quarterly. This covers maintenance on the tennis court, landscape, maintenance of common grounds, and maintenance and operation of the marina. This also covers landscaping for each individual property, an annual assessment for the Capital Reserve Fund of $2,000 per property. HOA docs are available for review. We didn't hear that tonight. You didn't hear that the lot that was perhaps designated on Pittsburgh has already perhaps been sold. In summary, there is no one right answer to the question as to whether to allow alternatives in lieu fees or off-site construction. But I do believe that the correct choice for this planning board is to take a vote and to hold this applicant to the 2020 August 25th decision of final major subdivision approval terms.
Anybody else care to speak?
I have a question.
Public closed?
Pardon me?
Public closed?
I'm sorry, public is closed, yes.
I have a question related to the fact that can these properties be sold if they are still within contract of being low-income affordable housing?
No. Can't close on a property if it's designated unless we get relief from this board. Those units can't be sold.
You said the units
The answer
can't
is
be
no.
sold unless this board changes its ruling on fair share housing.
The answer is no, sorry. Yeah, okay.
I have another question.
Let me state that. They can be sold, but they would still be subject to the approved site plan.
Sure.
So people can sell things all the time that they shouldn't, but it's until they change your prior approval, it has the approval, it'll never get a building permit.
Well, you're saying it won't get a building permit, but according to what I read in the law is that this affordable housing are supposed to be built almost in the beginning of the phase one and not at the end. So that to verify.
Consistent with they'll never get a building permit.
Right, and
Well, but the thing is I read in the law that that for low-income housing, that housing is supposed to be built before the other housing, to verify that housing gets built and not.
COA provides that affordable housing gets phased in, but it doesn't provide that you build all the affordable units and then build the market rate. It's built in phases.
Right.
And that's to prevent builders from building all the market.
And then walking
not
away.
building the affordable. But all the units have not been sold, so the phasing requirements have not been violated, the COA's phasing requirements.
Okay.
What are the phasing requirements on the development?
Off the top of my
that's all
head, I
the
think
information we'll bring back to you.
Yeah, I think 20% you have to build an affordable unit, 20 or 30% off the top of my head, you know.
But there is a phasing in place.
You have to phase the
And you'll provide that, you'll provide that.
Yeah, was that in your report, the phasing?
Yeah, because you're
We'll get you that information.
yeah, because you're getting close to being that.
Well, that's why we're here today, quite frankly. We're at the point where we have to
Bill, question
have a decision on the
for the attorney or whoever. Are these lots on the market, and are they being advertised as affordable housing market?
I don't know the answer to that.
Who does?
I don't think they are at this point.
Well, in other words,
That's
none
why
of
we're
you,
here
Can someone answer
today.
the question who can swear to the truth of it? Yes, no, I don't know.
I don't know.
you don't know that the real estate agent marketing,
13 lots there, some one realtor had, the other realtor had another one.
or is the marketing of this house, with several lots still on the market, you're saying? Are any of them identified as affordable housing? Why not?
You know,
Just
Tom?
what's on the plan that
Right.
Can you speak into the microphone, please?
Yeah, there's two that were identified as affordable, and neither one are built.
The houses aren't built, but, I mean, I drove by there, and on Pittsburgh, one of them is on Pittsburgh, and there's a sign in front of every lot that says under contract on Pittsburgh.
No, they're not under contract. And the affordable houses still are baking around it as we sit here.
But if we went online and we typed in the address of that affordable house on Pittsburgh, would it come up as being on the market?
That I don't know. I don't do the real estate, but it's not
Well,
built.
out of the three of you, who's in charge to know that?
The realtor does it. It's with a realtor that has the listings.
Well, I don't think a realtor would take liberty of that.
Is Craig's going to make sure, that, and the number is 5, by the way. And once you build 5, then you got to start into your load of mods. And that's where I'm at now with Craig. He doesn't want me to start the 6th or the 7th, so that's why I'm here right now.
Okay. Well, when you return, I hope you have answers to the questions, especially the one I asked at the beginning as to exactly why do you want to move these 2 affordable housing lots onto Lafayette? It hasn't been answered yet.
Well, I could have this room filled with people from over
Tom,
there.
we'll hopefully can answer your question when we come back.
Okay, thank you.
What's on the floor, Bill?
Pardon me?
What's on the floor right now?
What's on the floor?
What are we doing, what are we just,
Well, on the floor is to allow us to be withdrawn and come back.
Continued.
Information, we're continued. Yeah, thank you. Has that been, the motion made? You made the
Can
motion?
I ask, is it withdrawn or tabled?
Okay, the
Adjourned.
motion that the chairman is soliciting, if anyone wants to make it and it gets a second, is to adjourn. If it doesn't get that motion and a second, then it's not adjourned. So the chairman is soliciting motions to adjourn. And then he'll listen to see if anybody makes that motion, or he'll make it, one of the two. And then you'll see if it gets adjourned.
The request was to adjourn and bring back the information that we weren't able to provide tonight, and give you guys more information, answer your questions.
Do I get a motion?
I'll make the motion to adjourn.
Second?
Okay, we have a motion by Mr. Belasco, seconded by Mr. Jones. Mr. Lundholm?
No.
Mr. Crowley?
no?
Mrs. Reed?
No.
Deputy Mayor Sheehan?
No?
Mayor Mullick?
No.
Mr. Gorgon?
No.
Mr. Belasco?
No.
Mr. Jones? Yes. Mr. Bezare?
Yes. Where does that leave us?
It means we withdraw, it means we withdraw the application.
Pardon me?
That means we withdraw the application
Okay,
to be refiled.
okay.
Okay?
All right.
Thank you all very much.
Well, hold on a second, let me. I need a minute to think about that. Or you can, are you,
The application is withdrawn. We have
I-
removed it for the board's consideration.
okay. Mr. Chairman, are you okay with that? And I'm not saying yes, I'm just asking if you're okay with it, and then we'll move past it.
Yes, that's fine.
We don't have to vote on that?
No. You really can't tie my hands to vote no on the application.
Well, I need you to tell me, that's a
look,
fair question. I'm trying to figure out if you can withdraw after you've put in your case.
There's nothing that says that I cannot do that.
Well, that's why I asked the chairman, and now's the question whether we vote, and I gotta give that some thought.
What did we just vote on?
You voted to not adjourn it, so now you're back in the application, so now the question.
And I'm withdrawing the application from
I
consideration.
understand you wish to withdraw the application, but now it's with us, so we decide what happens with it. So let me just give me a minute to think about what happens. You don't necessarily just get to put all the evidence in, see how it's going, and withdraw automatically. I gotta give that some thought. I'm not saying you can't, but I wanna give it some thought. My guess is that that might not be the board's desire, so I don't wanna preclude them from that without me thinking about it, so give me a minute.
Bless you.
Bless you.
I actually have found the answer, I'm just reading it, so bear with me a second. Okay, I'm gonna tell you what the law is, and then you guys can decide what to do. And Mr. Bailiffson, you'll hear what the law is too, and then you can decide what to do. 18-7, withdrawal of application. I'm gonna read the whole thing because it may end up mattering a lot. In Sandstone, Oldsmobile Cadillac versus Shrewsbury Borough, 211, New Jersey Super 304, Law Division, 1986, the court dealt with the question of whether an applicant, after the conclusion of the hearing and when it is becoming evident that the board is going to deny the application, has the right to withdraw the application without prejudice. Meaning, without prejudice means they can come back. So this is directly on point, is what that says. The court, pointing out that a zoning board of adjustment is a quasi-judicial body, or not a zoning board of adjustment, but I think it still applies, compared the withdrawal of an application in such circumstances to the taking of a dismissal under the court rules, and concluded that where an applicant seeks to withdraw a pending application before a zoning board of adjustment without prejudice, the principles of Superior Court Rule 4:37-1B should be applied. This rule provides as follows: by order of the court, except as provided in paragraph A hereof, which deals with when everyone agrees, an application shall be dismissed at the plaintiff's instance only upon leave of court and upon such terms and conditions as the court deems appropriate. Unless otherwise specified in the order, a dismissal under this paragraph is without prejudice. In the case in question, the board had denied the applicant's request for withdrawal of the application and proceeded to deny the variance. While the court held that this was not an abuse of discretion by the board, it pointed out that the board could have granted the withdrawal on certain terms and conditions, as, for example, requiring the applicant to reimburse the borough and the objectors for all expenses, including attorney's fees incurred in the variance application. The court indicated that the board should have at least considered any appropriate terms or conditions for granting a withdrawal of the application without prejudice. The court remanded the matter to the board for that purpose, being careful to point out that the remand should not be construed as a directive to grant the request subject to terms. The board was only directed to consider any appropriate conditions for withdrawal and to report its determination to the court, the board being perfectly free to reaffirm its prior action. It should be noted that in this case, the board rules apparently contain no provision relating to withdrawals, for had the board adopted such a rule, it would have been binding on the court provided it was reasonable. I don't know if we have such a rule, but I'm going to talk to you about what that, just in general, my understanding of that rule, because that's something that lawyers deal with. So you could have a case that's in court for 3 years. A lot of money is spent, time and money and effort on the court's part, on the opposite party's part, and then it's not going well. The last one part says, I withdraw my case. And you can't do that. The court says, well, wait a minute. I'm not going to let you just start this whole thing over after we've all spent all this time and money and effort. So I'm going to, maybe I'll let you do it, and maybe I'll let you do it on terms. So you pay the attorney's fees of the other side, or you reimburse all the court costs, and the court can put terms on it before you, or the court can say no and say, look, it's too far gone. we're ready, we know what we're gonna know, it's unfair to the objectors and the other people that participated, all that stuff. So it's in your discretion, again, discretion, whether to grant a withdrawal or not grant a withdrawal. That's what this case says. So in the case that sounded very similar to this one, the board refused to grant the adjournment or the withdrawal, refused to grant the withdrawal, voted and said no. And the court didn't reverse the board. It said that it was not an abuse of discretion, but the board should have considered what they call less severe alternatives, which is, well, are there conditions that you would put on the applicant that they, in order for them to be able to withdraw? And then the court also said, you don't have to put those on, but the court directed that you at least consider them. So I'm directing all of you, if you're inclined to deny the withdrawal, to give some thought to if you think any terms and conditions are appropriate. I'm not saying you have to have them, but it sounds like I'm supposed to tell you to think about that. And I think I was right not to just let it be withdrawn because there is a case on it. So let's have a little discussion and then an appropriate motion.
Can I be heard in response?
Absolutely.
We withdraw it because every board member who spoke was looking for information that we couldn't answer some of those questions. And the idea was to give us an opportunity to do that. We would all be more informed if we did that, you guys for the next case and us for the next case. We didn't anticipate the depth you guys were going to go with this, and we'd like to be able to come back and answer those questions and provide the information. It's a huge volume of law, affordable housing. I don't know it. Linda knows a lot more than I do, but we'd like to be able to at least look into those issues and bring that back to you.
I'm sorry, I got to say one more legal thing, and then you can say what you want. I would just say, from the lawyer's perspective, the person who is assigned the job of defending your decisions in the Superior Court, okay, if you're going to deny this, you're more likely to be upheld on a full record with all the information before you than you are on the present record. I'm not saying you'll lose in court. I'm just saying, from my perspective, I just think it's easier to defend the denial, if you're inclined to deny it, if you've heard all of the information and it's a complete record, and the court says, well, they heard it and they exercised their discretion and they weren't unreasonable or capricious or arbitrary because they allowed the applicant to present all the information they wanted, they allowed them to answer whatever questions and give their best answers, and then they denied it. That's easier to defend. I'm not saying it's undefendable if you just deny it. I'm just telling you that I don't want to tell you that later and say, oh, well, we lost an appeal, and if I had more information, I might have been able to do better for you. I'm telling you that in advance.
Rich, can I have a question? You raised a new issue a little while ago when reading that, and you raised the possibility that there could be other alternative ways for meeting their obligation with respect to our affordable housing requirements. Is this an appropriate time to raise some of those, or what would they be?
I don't remember saying that. What I thought I said was that there may be, the court is kind of asking you to look for a less, if you deny this now, it's res judicata.
Yeah.
They can't bring it again. They lose. That's a very drastic event. So I was just saying that maybe there are some terms and conditions, the court's asking for terms and conditions that make it so that they can withdraw it, but that the harm to the public or to the board is diminished by the terms and conditions. That's what the court does under that rule. So
Right.
they'll say, you can withdraw it now, but the other side just spent $38,000 on attorney's fees, so I'm going to let you withdraw this the day of trial, but you got to pay their attorney's fees if you want to withdraw it. That happens in court.
But doesn't that language give us the opportunity to suggest to the applicant that maybe this way isn't the right way, but there's a different way to do this?
Well, I think that what they want to do is they want to come back and talk about other ways, and if you have other ways that you want to say now's a good time, because that informs them. So they tried, hopefully Mr. Bailison took some notes and listened to your concerns, and he said specifically, I'm going to come back and try to answer your questions. You might not like the answers, he may not have good answers, but he wants to give it a shot.
But is your follow-up information going to be solely and only directed at this particular request, or is it are there going to be broader issues raised in their responses to us? What's that?
If we can come up with alternatives, we're going to come up with alternatives, if they're available.
I'm
We'll do
sorry,
what we can to get this approved.
Suppose he has a 3-bedroom house laying around town, he comes back and says, look, our affordable housing we're going to give you is actually a 3-bedroom, 2-bath house and a 4-bedroom, 2-bath house. You may say, well, that's a little bit more like what we envisioned in the other ones, and that might be okay. So you're going to let them come back and see what they got.
Well, my point is, though, because they weren't, I'm going to say, prepared for us tonight with all the questions that we were asking, what gives them the right to say we're going to withdraw it and come back now that we realize that we weren't prepared enough. Because basically, that's what it's coming down to, is that they weren't prepared to answer our questions, and now because they couldn't answer the questions, they want to take it back and then come back with other answers that, you
No
know.
one says they have the right. I said the opposite of that. I said that they can request it, and then you have discretion to deny it. So no one says they have the right. I'm saying that they,
Right, okay.
that's what they want to do, and you may not let them. And that's up to you. I've read the law. My job's to tell you the law. I did it the best I could on 30 seconds' notice, and now you got the best I got. So you have to make your decision.
But if we approve the withdrawal, though, then they do have the right to reapply. But does the current resolution then stand as written in the meantime?
Yes.
Nothing has happened to that.
Yes.
Yeah.
Okay.
And I, reading between the lines, Rich is suggesting that he would need more ammunition to properly defend the denial.
Well,
Short denial
I
tonight.
don't, no, I don't need more. I probably have enough to do it. I am just saying that, in my experience, when you get to Superior Court, remember, they're bound by the record below. And that's very frustrating to judges who are used to getting all the information they want. But on prerogative writs, they're stuck with whatever happens at the board. And they get very frustrated when they don't have a full record, because now they're stuck with a third of a record, or half a record. So what they do a lot of times when they're faced with that situation is they send it back down, and they remand it, and then they get a fuller record, and then they'll decide it. And I'm just cautioning you that a remand is more likely when you don't allow additional information. So I'm not telling you can't do it. I'm just giving you, you guys may not have done some prerogative writs. I've done, 100, so I have a little better handle on how they tend to go.
Well, the other side, in my opinion, is that this is new territory for us. We've not really done this ever, and it could be a learning experience to find out what exactly is allowed and what's not allowed, and let them educate us.
Mr. Chairman, can I ask a question of Mr. King, and another more legal one? Just if we were to allow this to be, I forget the word we're using, withdrawn. We had public here that may have spoken. I think the idea was that they were going to withdraw it, and we were going to kind of limit public comment because it was going to be withdrawn.
It's going to be adjourned.
Adjourn, okay, thank you. And that's kind of part of my question. And I don't know if anyone was represented by an attorney this evening or whatever. Obviously, public comment is closed. But my question would be, if this were to be withdrawn, you talked about some of the legal fees and things like that that could potentially be reimbursed. That would be a question that I would have if we were going to withdraw that, a condition of withdrawal. Basically, does somebody have an attorney?
The court told you to consider terms and conditions, so
And
you're
that was-
doing that, so I can't say that's an irrational term and condition. That's what the court rule is directing you to do.
I only ask it because I don't know if there was an attorney here that would have spoken if they didn't think it was going to be withdrawn.
I think
or
the public was open, everybody who was going to speak in the public.
Understood.
Spoke, yeah.
I agree with that.
Norm, Mr. Briggs, what application are you here for?
I'm here for this one. And I represent the association next door. We weren't going to comment because it was adjourned. So,
I suspect that,
but I'm not, that, whether we were going to speak or my client was going to speak, that shouldn't make or break the board's decision.
I think they will take a withdrawal.
I didn't want that to confuse the decision that we make here tonight, that's all.
That's
You
fair.
know, if an attorney,
Yeah, no, I think that was good. I think the groom side is, covered. We've got everybody on the side.
So you're saying, if I understand you, that you'd be better off with a full record, including terms and conditions of the proposal and why it's invaluable.
Look, I'm very transparent, if
Yeah.
nothing else. I started the hearing off by saying, I really don't understand completely the standard we're supposed to apply and what really matters. And remember, I started off the entire hearing that way?
Right.
And I got some answers, and then I got the Stone Harbor thing, but it doesn't really say it. It kind of throws it back to the state to decide it. So I'm not really clear on what the state applies to decide if you can do it off-site. It's kind of extraordinary to me. I don't understand the concept of inclusionary and then putting it off-site. It's not all making sense to me.
But when you raise the issue of terms and conditions, who sets the terms? Does the applicant set that, or do we
You don't
set?
have to set current terms and conditions.
Terms and conditions could be like, you guys can have your adjournment, bring us all the information back that we asked for,
Right.
for instance.
Well, he could have given us that information tonight, actually, but okay.
I can't,
We hear a lot of applications where we adjourn and let them come back and do, and resubmit what they, to answer our questions. We do that all the time. I mean, there are consequences to them for withdrawing, by the way. I mean, they're going to withdraw, they have to renotice, it costs them hundreds of dollars to do all that again. So, I mean, it's not all roses, you know, again, losing an adjournment is, that does matter. They lost that because then they could just, I make the same awards and they come back. So now they have to renotice and do the 200-foot list and do all that fun stuff and kind of start over. So they have to
Well,
pay Steve
first-
again, they have to pay Craig again to review it. I don't really, I'm not a big fan.
But I want to make sure that there is that point that we said that they can't move forward on building on these lots, right? And
Craig has made that very clear to them that he's. not
Yeah,
going
we've stopped issuing permits. They're at a standstill until they can resolve this issue.
we'll agree
Or
with that.
go back to the,
Or go back to the regular plan.
right, and then build the affordables on site.
So I would,
and we also need the recalculation of that affordable if those
We'll look
become.
into that, yes.
so I said, someone make a motion to allow them to withdraw, and then vote how you feel. Yes means they can withdraw, no means they can't.
Can I ask one question? And just because I like to think about these things, but if the board denies the withdrawal and denies the application, that does not preclude the applicant from coming back in with something similar, but different.
It would have
Res
to be-
judicata issue, like, so if they,
My preliminary reaction to that is they could come back in, but not to put off-site housing where it is now, where they're.
right, and it has to be a different site or a
If they
different.
came back with 2 3-bedroom houses, that would be substantially different, and res judicata would not apply.
Right, so by denying the withdrawal, you still could see it back. That's what I was
You would
saying.
just see a different.
A different proposal.
Substantially different version of it.
May come back with that anyway.
Right. Well, that'd be a
Right.
good plan.
That was my question.
I'll make a motion to allow the applicant to withdraw.
So yes means they can withdraw, no means the hearing continues.
Okay, we have a motion by Mr. Belasco, seconded by Mr. Jones. Mr. Belasco, I'm sorry, where are we still talking?
Continues tonight?
Yes, it's neither withdrawn nor adjourned, so that means you're going to vote on it after this. So you haven't adjourned it, okay, it works like this. We're in the hearing. You didn't adjourn it. If you vote no, if a majority votes no, then they haven't withdrawn it. That means we're still in the hearing. The thing you do next in this hearing is vote. So vote on the application. That's the only thing left to do.
With what we have.
Right, so now it's yes, you're allowed to withdraw, then we're done with this for now, they're done with this application for good. They make another application, it's without prejudice, they can make the same application, which would be a terrible mistake, but they'll come back and they'll make probably a little bit different application with more information and, you know, answer some of your questions and stuff like that.
So that raises the practical extension of what Craig just said. If you stop the process here, they'll be back with a different proposal.
If you vote no, they'll be back, okay, hold on.
Come back anyway, one way or another, come back.
It's confusing.
Or they take us to court.
That's another option. All right, so I'll do it again, but please, you know, all right, so you're going to vote on whether or not they can withdraw the application. If the majority vote yes, that they can withdraw, the application is withdrawn, never happened. And then they can come in and they can apply. They could come in with the same exact thing again. But if they come in with the same exact thing again, with the same exact answer to your questions, I think they see how it's going to go. So they may come again with the same thing, but with more information, and they may persuade you. Okay? You understand that part?
Sure.
Okay. Another thing happens. We vote on whether they can withdraw, and you say no. Then we're still in the hearing. Now we have a vote on the application, on the substantive decision to vote. If you vote yes for it, well then great, they move on, okay? And they have their approval. Let's say theoretically you vote no, and you say no, and you deny the application. That brings about something called res judicata, meaning it's been decided, okay? And they can't come back with the same application again because it's res judicata. I won't even let you hear it. I'll just vote I'll just have you vote res judicata. They could come back with a slightly different version, not slightly, but a substantially different version. If it's substantially different, res judicata doesn't apply. So you would hear it all, you would hear whatever they have to say. Got it?
Oh, sure, I know what you're talking about.
Then they can also take us to court.
Yes.
Are we done all testimony?
Yes.
We're done all testimony right now. Now we're voting.
They can appeal any of those decisions.
Okay, are you ready for me to call the vote?
Yes, but
No,
Yes.
there's no motion.
Oh, there was a motion.
Motion to withdraw? Was it seconded?
I
Yes.
second.
I apologize. Go ahead, go.
Okay. Motion by Mr. Belasco, seconded by Mr. Jones. Mr. Belasco?
I think enough questions have been raised on this application that need to be answered, so I'm going to vote yes to allow the applicant to withdraw.
Mr. Gorgon?
Yes.
Mayor Mullock?
Hearing the advice of our attorney, I vote yes.
Deputy Mayor Sheehan?
No?
Mrs. Reed?
Before I vote, I'd like to just preface that there seems to be a pattern here. You applied to build on that property, and you agreed to the terms. Then you come to us tonight, and you want to change it, and when it's not going your way, again, you want to change it and go away and come back again. I hope this isn't a pattern. On the advice of the attorney, I'm going to go along. It's a yes vote for that, right? Yes.
Mr. Crowley?
I would like to vote yes, because I am looking forward to a very different and interesting new way of solving their problem, because the one on the table doesn't seem to carry much weight. So I'd be more than happy to hear another option, as long as it doesn't include any of this one.
Mr. Lundholm?
Under the advice of the attorney, yes.
Mr. Jones?
I vote yes. I don't need the advice of my attorney.
You're an appraiser, you don't need an attorney.
Mr. Becerra?
yes.
Thank you.
Okay, we'll come back.
Thank you.
Oh, yeah, we do.
We have the lamppost. Oh, gosh.
Thank you.
They were going to go against this one.
Okay, next on the agenda is New Singular Wireless PCS LLC, otherwise known as AT&T, I guess. 1036 Beach Avenue,
Motion to approve.
adjacent to Block 1101, Lot 4.
Good evening. For the record, my name is Christopher Quinn, Quinn, partner with the firm Pinellas Halpern. I'm here on behalf of the applicant, New Singular Wireless PCS LLC. Everyone knows them in the marketplace as AT&T. I actually found that last application quite interesting, so I learned something new every day, and I hope this is not as interesting to you in terms of novel legal concepts.
This is a branch of AT&T?
New Singular Wireless is one of the entities owned by AT&T Corp. So they are the corporate entity that owns all of the FCC licenses. AT&T has put all their FCC licenses in New Singular Wireless's name. So AT&T Corp is the parent company.
In fairness to you, Mr. Quinn, Mr. Quinn and I spoke a week or two ago about this, and he has this stable of incredible experts that can tell you everything there is to know about, 5G wireless technology and all that, and I begged him not to do that. So he has them available to give you this huge level of detail, but for reasons that Craig will tell you later, this really shouldn't be all that complicated. It's a conditional use of specific conditions, and if they meet those conditions, you sort of have to say yes. So you don't really need to know all the details about wireless technology and impact on brainwaves and all this other stuff. But he has these folks kind of available. So I've asked him to kind of stay focused. If you have questions, you can do whatever you want, ask him whatever you want. But he has pared down his presentation for good reason, in my opinion.
I'd like to hear the details.
Yeah, you would. I figured you would. That's because you've been susceptible to,
Well, you can,
you've been,
well,
you've encountered those radio waves too often.
Well, thank you. Again, the property you mentioned, again, it's on Beach Avenue. It's adjacent to 1036 Beach Avenue, Block 1104, Lot 4. It's actually what AT&T is proposing is what's called a small wireless facility. It's going to be in the municipal right-of-way. What they're looking to do is there's an existing light pole right there, and they're looking to replace the light pole. The light will be in its place, the wood pole will be removed, a new pole will be in its place, looking pretty much like it is now, a little bit higher, with AT&T's able to put an antenna on top and some equipment on the side of the pole. It's called a small cell wireless facility. The purpose of this is effectively to help fill in some small gaps in service, to help alleviate some of the other sites that are providing coverage to Cape May. That's the project. The pole is going to increase in height a little bit, but it's within your ordinance's height requirements. So Cape May did adopt an ordinance recently which specifically addresses this type of facility, a small cell facility in the municipal right-of-way. They made it a conditional use. They said we have to come in front of this board to do this. We have to design it a certain way. Has to be set back a certain amount. Has to be a height limitation. We've complied with all those requirements. And in fact, we had an application before, previously that was contemplating a taller site, but when we looked at the ordinance, said you have to limit it to 35 feet. They limited it to 35 feet to meet your ordinance requirements. So what we have before you is an application, which what I submit is a fully conforming conditional use application. So we're requesting conditional use and site plan approval. Now, in terms of witnesses, I do have our civil engineer here, I think, who can just run through the pieces of it and explain to you how we meet the conditional use ordinance. We can also defer to your board engineer as well, in the most efficient use of your time. But I do have other witnesses here that can talk and answer questions, whatever you may have about this.
Craig, you comfortable just going through it?
I'll do it.
Okay.
Craig, can I ask just a quick question, procedurally? Does this still have to go before HPC?
Yes.
It-
That's all.
So
We
that'll
have
be-
HPC approval.
Oh, you have it?
Yes, we do. We
Okay.
already have a copy.
Oh,
I can
perfect.
provide a copy to the board.
Thank you.
After the fact. So this has been approved by HPC.
Thank you.
I also have one question. It said the location was round or about in that spot. Is it in that spot, or is it,
So,
It's in
Ac-
front of the Ocean Club.
right?
yes, so the reason why we have to say that is
Right.
because your ordinance has, you designate lots, okay? So the front of the property is their property, that private lot. It's not in that private lot, it's actually in the right-of-way. But we use that as an idea to give you a bearing as to where this is. Where the location of the pole is going to be located is the exact location of the current pole.
I'm only asking this because I had people were concerned, and that's why I was asking, just
Absolutely.
for clarification.
And again, this is, so typically when you've heard these applications in the past, I know this is probably new for the board, it's new that's kind of coming about, and honestly, it's one that a lot of towns don't necessarily have these types of planning board applications on, but it's perfectly fine that Cape May does. But effectively, you're used to seeing these applications where the antennas are 6 feet tall, and there's 12 of them or 15 of them on a rooftop, on a tower, on a water tank. The equipment is 6 feet by 6 feet, 7 feet, 11 by 20. Those are what they call a macro cell. They provide the normal kind of footprint of coverage. This is one where there's very limited purpose here, and it's really to offload and to help out just in this very targeted area within Cape May. So it's not one that is going to be used to provide coverage for the entire community, but is one that's really going to offload a problem in this one narrow area and help around the beach, up and down the street, a very short footprint of coverage, but it'll help alleviate capacity to the other sites. So when people are here in the summertime, there's not going to be any problems with service, not going to be any problems with accessing 911 or anything else. But that's kind of just a background on this type of use. Again, I can proceed however the board would wish me to proceed.
Can all mobile carriers utilize this?
No, this is for AT&T, only for AT&T system. So everything is proprietary from the other carriers. They would have to go to another type.
The pole's going to be, what, 2 feet higher and can it still have a light?
Yeah, the light will be the exact same height. It'll be, I believe what it said is that the current pole is
About 2 feet,
about
about 2 feet.
2.5 feet, 2 feet, 8 inches. So
And the equipment's going to be at the top of the pole.
the antennas will be at the top of the pole. Above the existing sign on the pole, there'll be another small box called an RH, which is all shrouded and will be brown and will be painted the color of the pole.
I have a question. A little technical, but what's the size of the grounding grid? I see you have 4 rods here, and it's just schematically.
I'm going to defer to my civil engineer. So, I'll have Mr. Chan come up.
Because I know sometimes it's all on the ground, but they can be onerous.
Sure, this is a little bit different, again, this is a little bit different from the previous one. It's again, it's a wooden telephone pole, a wooden light pole.
Because that determines how much ground gets disturbed when.
Sure. This is my witness, Paul Chan. He's a civil engineer. I guess we can, might be the best way to do it is just have him answer any questions you have from the actual design. You have to be sworn.
Can we get that name, please? I'm sorry. I didn't get the name.
Paul Chan.
Paul Chan,
Paul
Can you
Chan?
spell it, please, for the record?
P-A-U-L, last name C-H-A-N.
C-H-A-N? Thank you.
Questions, let Craig go through, and then if he doesn't answer the questions, then they can ask him questions.
Engineer, correct.
Yeah, I guess, can he, Mr. Chan, be sworn in?
Once the chairman has a plan.
I think we're going to have Craig go through this first. If
Okay.
anybody has any questions, then Mr. Chen can answer.
Okay, perfect, perfect.
So, my latest review memorandum is dated April 22nd, 2022. This is our first review of a small cell wireless facility that's proposed in accordance with ordinance number 416-2021, which is our new small cell wireless facility standards. So with regards to completeness, I'm just going to touch on the important parts here and help Mr. King write the resolution. Under the completeness review on page 2, 52587, Conditional Use Standards, Section 3D has the application requirements. Item number 4 was the only thing that they didn't provide, and it says, "Small cell wireless facility shall comply with all applicable building and safety codes." That's obviously got to be a condition of approval, so that should, the record should reflect that.
Yeah, and that would normally come out as part of a building permit application.
Yeah,
And that's
so
when that's being reviewed.
That's going to be a condition of approval. I'm going to move on. So this is an application for site plan, preliminary and final site plan, as well as conditional use approval. So conditional uses, so long as they meet all the conditions, it's a permitted use, and therefore it's appropriate for this board to hear it. If it's not, if they don't meet all the conditions, it would have to go to the zoning board for use variance. So in this case, what they've provided meets all of the conditions of the conditional use standards. So they're a permitted use. This is appropriate for the board to hear, and therefore they're right in front of the right board. There was one issue with the conditional use standards, and there's a requirement that says they have to be, and this is on page 7 of 10, under section 5A, maximum size and design of conditional use, under one poles, item number 2, no pole shall be further than 18 inches from the curb line. We've just asked them to provide some additional dimensions on that to verify that they're going to comply with that. It's in the location of the existing pole. We just want to make sure that they're going to meet that. So that should be a condition of approval that they add that information to the plan. Okay, all of the height requirements have been met. The design requirements, the mayor asked about whether they had to go before the HPC. You've indicated that you have. Now, we have a conceptual approval as well as a final approval. Do you have conceptual or final? And what was the date of that, if we could have for the record?
We have, it says HPC approved, dated, it says final approval from HPAC from September 2021. I can provide a copy.
Okay, so just so long as that's in the record. So they've met that condition and condition of approval, so that's taken care of. All of the other information in here, I've just gone through, since this is our first review, we've just gone through every section of this and indicated that they comply or whether the information is required as a condition of approval. So the information that I highlighted should be a condition of approval. Under general review comments on page 10 of 10, Our standard condition that they have to provide the inspection escrow, and we have to sign off on the improvements, that they're consistent with the plans, that they have to comply with the recommendations of the Shade Tree Commission, Police Department, Cape May Fire Department. We did receive those reports. Environmental Commission provided a report, no comment, dated May 3rd, 2022. Fire Department approved, dated 4/25/22. The Police Department approved, dated, I don't know what that date, 4/25/22. And the Shade Tree approved 4/25/22. So all of those reports have been issued, and the applicant is required to comply with any and all state, county, and local approvals.
So it's your opinion that they have complied with the conditions of the conditional use, with the exception of the building permit or the construction code stuff, which they'll do as part of the building permit?
Yes, and provide the distance from the curb line as a condition of approval.
Mr. Chan, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, with regard to that last condition about the construction permit, do you believe you'll be able to comply with that?
Yes.
I mean, I misspoke. With regard to the distance of the pole, do you know what he's talking about? Can you?
Yes, the pole, we're going to be replacing the existing pole, so it's 18 inches from the curb.
There we go.
I just have a question about the fee that's stated in here. It's $210 per year.
910.
That is a function of federal law, and that doesn't apply here. That's the fee. There's federal law that talks about how if there was an agreement in place with the municipality, what the licensing fees are permitted to be based upon that fee. This is with the utility company, because that's the entity that has the license rights over these types of poles, and that's the fee that AT&T will be paying to the utility company.
Okay.
So it's just not relevant.
Yeah,
for
that fee is for a city-owned pole and not a
Yeah, utility-owned pole.
utility-owned pole.
Okay.
That's the difference.
So I'm just asking this for informational purposes only. So as a city, we don't make any revenue on putting up these?
The way your ordinance is written, correct.
Okay, because I thought we had changed that. That's the only reason why I'm asking, and that we had put in a fee for wireless.
Well, that's a council question.
Well, it's in here saying that there isn't one, right? And so I'm just
I
questioning
think that
the
was,
fact.
if the pole was on a township pole, on
Okay.
a city-owned pole.
You're right,
That's what.
that's right, okay.
Again, it's
Right.
different just because of the ownership of
Right.
this particular pole.
It's
So
also
that's
a
when it
county
comes
road.
to, we were thinking, you're right, because I'm thinking back to when we did the water tower, we negotiated
Exactly.
the rates for that. Okay.
Yeah.
That was just clarification, thank you.
And again, I'm just curious, the size of the grounding grid, and it could affect the restoration of the sidewalk and.
It will be the same.
Yeah, the size of the grounding is required by the utility company. So I believe in this case it's the ACE. Yeah, ACE. So they require a grounding ring of 36 inches around
36
the
inches?
pole, yes.
Okay.
I'm just inquiring, I guess this is a dead zone, and that's why you need to put this, you're just having problems, AT&T?
Yes, it'll help alleviate service in the area, but also for capacity in the summertime.
So this will only be for AT&T providers. What if you're Verizon? I mean, are they, I don't know if you can answer this or not, are they having similar problems with having a dead zone?
Every carrier is different in terms of their network, primarily because of the frequencies they operate on and the heights they do. If you've ever noticed, I'm sure on the city water tank, carriers are at different heights. So each carrier that's a little bit higher, signal travels a little farther. It also depends on the number of subscribers for capacity services. So we can't speak to Verizon.
Right, I didn't-
It's like asking Coke a question about Pepsi's.
Exactly.
formulas and business practices.
My experience, not with 5G, but dealing with providers like this will probably be the start, and the other providers will probably be following suit and making proposals for their installations, but not at that location, because
That's what I kind of thought, so we could expect to have other proposals from other providers.
All-
I know you can't answer that,
I
I know.
can't speak to that. It's possible.
Yeah.
God forbid they think of this ahead of time and cooperate as a condition of this law, that they actually use all the same things, so we don't have 4,000 of them. That would have been outrageous.
Yeah, you ought to get together and just do one.
Look, the trade-off realistically, from a planning perspective, let me take off my attorney hat, but from a planning perspective, the difference is this. You have a tall structure like your water tank in the city, and they have every carrier on there, but it's a very large structure. Here you have a 35-foot light pole that's being replaced with minimal equipment on it. So you might have a couple of those as opposed to this very tall structure that I think a number of residents might be more upset with. And I'm sure that's what what was considered when your governing body adopted this ordinance, is that this is again, these types of facilities aren't meant to do the full complement of, a mile of coverage that some of the other sites do have. It's really just to pinpoint an area where they need to focus and give some relief for them.
And just another quick question. How did this come to your attention that this area needed it?
AT&T has their own internal monitoring system of their network, drop calls, coverage signals.
Okay, this wasn't brought to you by the hotel or
No.
citizens of Cape May or anybody, visitors?
It's everything with these phone companies is data driven. So they can measure when they have drop calls. They measure when they have, people say, sometimes people ask the question, do you have customer complaints? Honestly, sometimes if there's no service, you don't get a customer that complains. They just don't buy the phone. It's just a bad area. Or they're just used to accepting the fact that, when I'm driving home and I drive through one area on my way home, I just know I'm gonna be dropped right here, so I just get off the phone with my wife at that point.
Or maybe they didn't have service to be able to call you and complain.
Yeah, exactly.
Yeah.
So everything is driven by data, because it's objective, it's not subjective.
And I'm just going to ask, when you're putting in that pole, because I went down to look at that area, it's a lot of sidewalk around the pole right now. Should you damage any of that sidewalk, would you be replacing it?
Yes. That's why I asked the question, the size of the grounding grid, because they can be onerous sometimes. Yes.
I just had a question, probably nothing to do with this one, but the ordinance that's, as I understand, this is like you're identifying dead zones of your coverage, and there are X number of carriers all having dead zones. Does our ordinance address the proliferation of these dead zone installations?
Do you want me to speak to that?
Sure.
I think the reason we had the ordinance is to make sure that that doesn't occur.
Okay.
So they have to come before the planning board for approval.
Okay.
So if we get a proliferation, we'll probably not approve it.
So theoretically, it's a proprietary installation by a carrier, so other carriers could be coming and asking for these.
Definitely, yeah.
All right, that's all I want to.
What is the coverage area for that tower?
It's usually a couple of blocks, I believe, but is that safe? A couple of blocks.
Just another question. Could you franchise or allow other carriers to pay you to use this?
AT&T operates at its own frequency, so the issue is, again, what you're doing is in these sites, they're very small frequencies. Okay, so it's very small equipment boxes.
So you couldn't sell that use to Verizon or Cellular One or another
No,
company?
each carrier has their own
Frequency.
because they're all
Okay.
licensed frequencies by the FCC. They all operate at separate frequencies. Again, we have such small components here. It really is a function of the carrier's equipment. No, I mean, when you see things being shared is when you see a tall pole being built and they design it for each carrier or something to that effect. And again, from a planning perspective, that makes great sense because you're having one tall structure in an area. In this case, here it's a water tank that's, that I've driven by. And you're able to put all the carriers on that one separation requirements and whatnot. Again, it's all because of license and frequencies and interference and other technical aspects.
Yeah, I think one of the reasons for Mr. Ludholm's question about how far it would be from is that this pole is not far from the water tower. And I think that's why, if you're at the water tower, would it, just make it larger, but you're saying that you still need that?
Yes. Again, that's why it gets factored into that.
I asked too, just to, like, how many can we expect to see around?
I can't say. I mean, again, what I've seen is really, in New Jersey, what I've seen is they fill in one here and there as needed. It's not, you tend to see it in a more densely populated area. In this case, I think it's when you see your summer traffic is what, you know, you see an influx of people here in the summertime, that's what that's helping. Other times you see these types of smaller sites are in, you know, New York City. You see them on almost every corner. But that's not Cape May, you know, so it's those types of areas. And also if there's topography issues or something else that's really limiting, you tend to see that more. But again, that's not Cape May either. So I don't know, I can't say what will happen in the future. I just know that, you know, it's really not meant to be a universal solution for everything. It's going to provide coverage, and AT&T is going to be proposing sites on every corner of this, of the street. That's not what this is meant. This is meant for a very targeted, limited area, just to give offset.
Got that. No more questions? We care to make a motion?
I'll make motion.
Dennis beat you to it. How about you second it? Oh, my God.
What is the motion?
Popularity contest.
What is the motion to approve the application?
Oh, I'm sorry. Hold on one second. You're right. Stacy's right. We have to have
Public
open it
comment.
up to the public.
All right.
Yes, yeah. Yeah, sure.
Okay, thanks very much. My name is Elizabeth Hyde. I'm at 1007 New Jersey Avenue, and I'm here tonight to represent a number of my neighbors who we've had a number of things in the last several months that have affected, potentially affected New Jersey Avenue residents. And so we've been very happy that people like Mrs. Hendricks and Deputy Mayor Sheehan has brought to our attention. And so this was one that we just wanted to make sure that it wasn't going to be something else that was going to affect our properties. In that same vicinity, we have a lot of lights that are shining in our houses, and so we didn't really know what the structure would look like, or if there's going to be any additional lighting that might impact us, or that the height would be something that would add another something visual that would we'd be looking at. So, you know, based on my understanding of the application, it doesn't look like that's the case, but we just wanted you to know that we're keeping our eyes out and want you to know that, you know, we had concerns in that regard. So I appreciate your time. Thank you.
Thank you. Public portion's closed. So who made the motion? Bob?
I'll make the motion.
Second.
Motion by Mr. Gorgon, seconded by Mr. Crowley. Mr. Belasco?
Yes.
Mr. Gorgon?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor Sheehan?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley? Yes. Mr. Lundholm?
Yes.
Mr. Jones?
Yes.
Mr. Becerra?
Yes.
Thank you.
Thank you very much.
Okay, thank you.
If I can ask, is there a mechanism in town where they could proceed with their permitting while we're waiting for resolution, as long as they comply with the requirements, or?
Klein's plans for me,
Okay,
that's the first step.
okay, great, thank you so much.
Do we have a
Motion to adjourn.
I wore everybody out.
Thank
Second.
you. All in favor?
Aye.
All right.
Thank you.